Thank you, Aaron. I figured competing with a Texas-Michigan football game and the President of the United States, I know I'm great, but it was kind of a lose-lose or lose-win proposition. But anyway, thank you for being here. As Aaron said, this is my fourth in a series of and why books. They're not how-to books, they're why-to books. And I started writing them when Donald Trump took office, and I was reading in the New York Times an article that said the pardon power is absolute and has no limitations, and I wrote my first opinion editorial for the Baltimore Sun. And what I wrote is that that's an overstatement because the Constitution is all about balancing. It's all about making sure, no branch gets all the power. A monarchy is a triangle with the monarch at the top, and the monarchs, there's a divine right of kings. The idea was the monarch's power comes from the divine, that if you slay someone on the battlefield, that's because God wanted you to be king. And then the king would dole out goodies to subjects based on the subjective beliefs of the king. And that's the image of a monarchy. You flip that around, and that's a democracy, right? It's an inverted triangle. The people are at the top, and the power is supposed to trickle down to the subjects, right? Or with the people in power, that is like the president. The pardon power is this sort of area of law that is very rarely looked at, and there's this widespread assumption that the president just has absolute power, and including recently in the Supreme Court's criminal immunity decision, the court specifically held that the pardon power is so core that it can't ever be challenged criminally, even if it's used as a bribe, presumably. The fact of the pardon power, the fact that a pardon was given can't be used as evidence in a criminal case. The court essentially amended the United States Constitution, Article 2 of the Constitution, in that decision. It could not be more powerful and more monumental, and I don't think it's discussed very well that way, for the most part. I don't know if it gets its way to the Midwest, but the problem with it in particular is that the court held that if you use official power, right, power of the military, power over the FBI, the CIA, the IRS, spy agencies, nuclear codes, the ability to initiate bogus investigations, ability to arrest people. If you use that batch of powers and you commit crimes, that's protected, right? If you use private power and you commit crimes, you can still be prosecuted. So imagine you want to assassinate your political rival. You could either pull out your private handgun and do it, I don't know. I don't know how a president would do that, but like follow him to the bathroom or something, and at a party, and then you'd be prosecuted. Or you could say, "Oh, I'm going to have SEAL Team 6 do it." In order to get those people to comply with an unconstitutional legal order, you'd have to pardon them. So if you take the power of the president now to commit crimes using official power, and you marry it with the pardon power, then you have a crime spree, a crime gang in the White House. Now, people will say, "Oh, that'll never happen," right? You're exaggerating. That'll never happen. Well, I have two responses to that. The first is tell that to the framers of the Constitution, the people that fought a war to get rid of an unlimited monarch. They understood, as Madison said, that if men were angels, there'd be no need for a government. He also wrote in the Federalist Papers, ambition needs to be made to counteract ambition, right? We have rules. People who work in this library, there are rules for clocking in, clocking out. There are standards for employees. When you drive down the street, if you don't follow the speed limit, which we won't do for a lot of us, you get a ticket. Once you get the ticket, there's a camera hiding in the bushes, you'll slow down. So the power of the president's the same way. Where are the tickets for speeding? If there are no tickets for speeding, people will speed, because that's how our limbic system, that's how our brain stems are operating. We're wired to, some of us, most of us, once you have power, to acquire more, to amass more, to entrench it, and ultimately abuse it. So then the question is, okay, why do we have the pardon power? Why does it even exist? It dates back to 1500 BC, the Code of Hammurabi, ancient Babylonia, all the way through the Bible, right? The whole Christian religion, Christianity, was birthed by the lack of a pardon. It was Jesus or Barabbas that Pontius Pilate presented to the Romans on the Passover, and they could choose who would be pardoned, and they chose Barabbas, who was a murderer, and Jesus was executed. So that is the history of the pardon, and it's really about showing mercy. The idea is people slip through the cracks in this criminal justice system, and the sovereign or the people need to give mercy. At the time, the pardon evolved in common law England around the 7th century. There was no criminal justice system. There were no jury trials until the 13th century. Most of crime, as we know it now, was meted out through private parties. If you committed a crime against someone, you murder or an assault, the family then would do a revenge crime against you. It was this Hatfield-McCoy type circular process. And then at some point, the king came in and said, actually, I'm the divine ruler. The crime is not against the family, it's against me. And so I am going to use this, my divine power, to forgive crimes. And to some degree it mattered. There's a story in the book about a 4-year-old girl who pushed her brother into boiling water and killed him. The father had to secure a pardon, otherwise there would be, the severe penalties. A lot of penalties for death penalties for very low-level crimes. So at that time, and frankly at the time of ratification of the Constitution in 1788, there was probably a need to have a sovereign or somebody be able to just make sure people didn't get punishments that weren't warranted. And at the Constitutional Convention, there was a proposal to have the Senate approve pardons. There was a proposal to ban pardons for treason. And Alexander Hamilton and James Madison prevailed, and paraphrasing basically said, we need to have the ability of the president, with the knowing, thoughtful, sage way. And of course, they all knew each other back then, right? Supreme Court justice one day, president the next day. So they knew who they were talking about. And the idea was those folks really should have this power. It's also why we have a representative government, right? The Articles of Confederation that preceded the Constitution were very populist. You counted the votes. There was not a strong federal government. There was a concern that bad information would make people vote against their best interests. So there's this layer of representative government, the Senate, the House of Representatives, the Electoral College, all of that. So it was, I think, a similar idea, and it was a real distrust of populism, a real distrust of Congress as being the most dangerous branch. So they adopted it without a lot of debate. It does say in the Constitution that you cannot pardon for impeachments. That was actually taken from a limitation on King George III's power. But even under, by the time of ratification of the Constitution, Parliament had imposed limitations on the king. The pardon power had been shared with the clergy. Actually, you could also be pardoned by a Vestal Virgin like Lady Godiva. If you locked eyes with a Vestal Virgin, that means that the divine wanted you to be pardoned. So there was a lot of mythology around the pardon. It's really this mystical idea of grace, God's grace, okay? The other way that pardons have historically been used is for what we call amnesty. During COVID, all countries on the planet except China have some version of pardons, and some countries, pardoned prisoners when it was so they wouldn't die of COVID, right? The very first pardon under American history was George Washington after the Whiskey Rebellion, where they taxed distillers to pay for the Revolutionary War, and they got ticked off, and they protested, and they rioted, and he was politically rewarded for that, the idea that it kind of brought the country together. Of course, Abraham Lincoln and President Johnson pardoned Confederates, both during and after the Civil War. The idea being Lincoln was, we want them back in the Union Army. And then you had Johnson saying, well, we got to move forward. We have to heal this broken nation. And of course, Jimmy Carter pardoned people that had dodged the draft in the Vietnam War. Some people think it cost him re-election. So those kinds of pardons have that kind of political pushback. There's accountability in that way, in the way that private pardons have not, at the federal level anyway, been meted out, at least in the last few years. So at the turn of the 20th century, there was a small prison population, a few thousand people in the federal level. The president read every pardon application, and about 50% of them were granted. And when there were decisions made, the attorney general gave an explanation. There was also at some point, it was the Secretary of State who actually used the pardon power or had the power of the pardon at the federal level. Today, I mean, Donald Trump at the last administration, 60% of his pardons were in the last few days he was in office, and he granted 2% of the applications. Meanwhile, the prison population at the federal level has gone up 70%. And since 1984, there is no federal parole. There's no federal parole. So there's no mechanism at the federal level for adjusting for miscarriages of justice other than the pardon. And the Supreme Court has held in a series of cases under what's known as federal habeas. So if you're not aware, you can, if you're criminally convicted, you can appeal your conviction and you can say, okay, there are mistakes made at the trial or whatever. And you can also separately file a separate civil action through what's called a writ of habeas corpus and challenge your confinement. And there's separate laws for that, but you're basically arguing, I shouldn't be in jail. In the habeas cases, the Supreme Court has said, even if you find new evidence that exonerates you, shows that you are innocent, unless you can show your constitutional rights were violated through the process, you can't use habeas to get out of prison, even if you're innocent. Why? Because there's always a pardon. So there's this assumption, and I think it was Montesquieu who argued that the problem with the pardon is that it makes excuses for not actually fixing problems in the criminal justice system, because there's always this thing called the pardon that can make sure that I have my friends from Washington here. I think people are on their way to the football game, so it's a small audience. So that's where we are, and I argue in the book it's not being used. I mean, in some cases it's still used for justice, mercy. Alice Marie Johnson was pardoned by Donald Trump. She was looped into a drug trafficking problem, and she had addiction problems and other issues. Barack Obama said no to that pardon. Kim Kardashian got involved. Kim Kardashian secured the pardon, and then she was kind of, pulled out at the Republican National Convention and in political ads. Of course, famously, he pardoned Roger Stone, Paul Manafort, and a federal judge in Washington in connection with Roger Stone said on the record that she believed, and I'm paraphrasing, this was to keep these witnesses quiet. That's typical obstruction of justice, right? Bill Clinton was criticized for pardoning a guy named Mark Rich, who gave a lot of money to Democratic causes, but Congress and the Justice Department investigated those pardons to see if there was a pay pardon. There was no litigation brought or no criminal case brought. But the point being, we've seen this, but it's just escalated to the point in the last administration. It was pretty severe. And just last week, one of his pardons, Donald Trump's pardons, it was some man who murdered a police officer. He was pardoned through connections with Jared and Ivanka. Jared Kushner and Ivanka Trump, of course, Donald Trump's daughter and son-in-law, and last week he was arrested for strangling his wife. It's not the first person that's gotten out of prison that has gone on to commit crimes, and people say, well, then, we shouldn't use the pardon. I mean, every president, with the exception of Obama and Biden since Reagan, has run on a tough on crime platform. And people, they're shy. That being said, $8 billion, taxpayer dollars on average, go to prisons. As I said, there's no federal parole, so there's no mechanism for correcting injustices in the federal system. That's rounds to be over $800 per year per taxpayer. And so I argue if you're going to have a pardon, it should be used, maybe to address those injustices where people have long sentences or they're actually innocent. It's not being done. Barack Obama in 2014, under Eric Holder, had a clemency initiative where they did commute the sentences, I think about 1,400 people, based on criteria, drug offenses, no violence, no gang membership, and the laws today are more lenient than the laws when they were convicted. But that was really unusual. That was super rare. Why, people ask me, and I'm happy especially since it's such an intimate crowd, to take whatever questions. The questions I get, I was on Morning Joe this morning, and the question I got, what about a self-pardon, right? Everybody wants to know, is a self-pardon constitutional? My answer to that is it's the wrong question. The question with the Constitution is not what it allows. It's if people push the envelope, push the boundaries, is there a consequence? Is there a ticket for speeding? If there's no ticket for speeding, the answer is yes, you can do it. But my other answer to that is we don't need a self-pardon anymore. The only one who needs a self-pardon, possibly, for the rest of American history is Donald Trump. Why? Because under the immunity decision, you can now commit crimes when you're in office. So what do you need a pardon for? You can't be convicted of anything. So he's the last guy that's going to possibly raise the issue of a self-pardon, thanks to our friends on the United States Supreme Court, which I can talk about at length. So I think one way or the other, we're headed towards pardon land. I wrote the book because the publisher asked me to write the book, but it seems kind of like this, people think it's boring, and not that you're like, oh, what do we want to hear about pardons? But it's, Glenn Kirshner, my friend who's at MSNBC, he interviewed me and he actually read every page of it and he said, Kim, it's like a spy novel. It's a page turner. I talk about pardons, around the Mormons, for, trying to secede from the Union, for treason during the Civil War, and then polygamy pardons, and then all about common law England, this historical, religious connotations of the pardon all the way through the Constitutional Convention and through the present day, right? And the limits on the pardon. Newsflash, it's a myth. It's not true that there aren't limits on the pardon. The Supreme Court said you can't pardon crimes that have not been committed, not in the Constitution. Supreme Court has said you can't force someone to accept a pardon. That would violate the Fifth Amendment right against incrimination, not in the Constitution. Supreme Court has said you can't, through a pardon, force or direct as president that the federal treasury repay criminal penalties. If you had to pay $100,000 in fees or fines, criminal fines, a pardon can't get your money back. Why? That would violate the appropriations clause, that the power of the purse that is lodged in Congress. So the answer to the question, can you self-pardon? I think there are many limits why the answer should be no. How about the take care clause of Article 2 of the Constitution? The president shall take care that the laws are faithfully executed. If you're going to violate them, you are not adhering to that obligation and that prerogative. But that didn't persuade the United States Supreme Court in manufacturing criminal immunity for presidents. So how could this come up? Number one, Donald Trump wins office. He brings people into office. He says, I don't ever want to leave. This is my plan. You commit these crimes for me, I'll pardon you. Because I have no liability. I'm scot-free. That's option one. And by the way, I'll pardon the 1,400 plus insurrectionists in January 6th. Then I have my own private militia. And there's a study done this summer polling both sides of the aisle. Majorities of Americans, including Republicans, did not want to see the January 6th insurrectionists pardoned. Because they're worried that it's going to greenlight political violence indefinitely. We will reward you for political violence so long as it's for the right side, right? So that's option number one. Donald Trump gets in office, the pardon power plus the immunity decision really helps him never leave, or his gang never leave office, and that's the end of democracy. Kamala Harris wins, and she's going to have pressure, I think, to pardon him. There will be pressure. And what do we have, historically? We've got, Gerald Ford. I'm going to be back next week to speak at the Public Policy School with John Dean and Barbara McQuaid and Jill Wine-Banks. We're going to talk about 50 years since, Ford's presidency, and Ford famously pardoned Richard Nixon. And so I think there's going to be, the argument's going to be, we need this pardon to heal the nation after the division that happened after January 6th and all the fake investigations. I did a podcast today, and I was asked, what do I think of that? I think it'd be a terrible idea, which I can explain if anyone's interested. So it's going to happen one way or the other. And I think the last piece, everyone's assumed Donald Trump doesn't have in his top drawer in Mar-a-Lago a self-pardon that he gave himself the first time when he said publicly he could pardon himself. And so I don't know, he's not a dumb guy when it comes to these kinds of machinations. So I think it's entirely possible that Kamala Harris, if she wins, her Justice Department continues these investigations and prosecutions, and at some point he pulls out a self-pardon, assuming the Supreme Court allows either of these to go forward. That is the Mar-a-Lago one and the January 6th, which I think is unlikely, frankly, which I can also talk about. the dissenting justices said what the majority did was give themselves pre-clearance of any indictment against a president. So the Supreme Court basically made themselves the uber prosecutors when it comes to the president, which is really a violation of the separation of powers, I would argue. But I get in trouble. If you Google my name, you will see Kim Wehle, Democrat or Republican. And to me, nobody knows what political party that I'm aligned to, I think is probably a win. And I get that when I speak to audiences and stuff on C-SPAN and everything. So anyway, I've talked a lot. I could talk on and on. Thank you, my friends and stragglers who came out and care about democracy. And this is being videotaped. So if this is worthwhile, please share it with your friends. I'm so happy to be here. Any questions? Yeah. Yes. Miss Veith.
If I'm not mistaken, you at one point earlier in your career worked professionally with one of the sitting Supreme Court justices.
Yeah.
Based on what you knew about this individual then.
So that's Brett Kavanaugh, yeah.
Yes.
Mm-hmm. Yeah.
Were you surprised with some of his rulings, and particularly in the immunity case?
I have been surprised, and I said this I did an interview with Jen Rubin of the Washington Post, and she asked me the same question. I normally didn't used to answer that question. But yeah, I always thought, so I know Justice Kavanaugh from the Ken Starr investigation. I was an associate independent counsel in the Whitewater investigation, but really early in my career. And, Brett Kavanaugh is one of the smartest lawyers I've ever worked with. And so I sort of anticipated a more independent strain of thinking. But that was, before those really terrible confirmation hearings, terrible all the way around. I think it was a real trauma for the country. So, and this is not about Justice Kavanaugh. And I think people will say, well, what's good for the goose is good for the gander, right? So the Supreme Court gave Republican presidents unlimited power. They also gave Democratic presidents unlimited power. My problem with that, or like my pushback on that, is the court left itself, I think it was Sotomayor who said, left itself pre-clearance authority, right? The court didn't say this is private action, and if you do this, you can be prosecuted. Notwithstanding all the horrors of January 6th, the court didn't find anything in that scenario that gave rise to the Jack Smith's January 6th indictment, not one action that was not presidential. Right? There was nothing the court said, specifically said calling your vice president and directing him to defy the Constitution by not gaveling in the actual winner of an election pursuant to the will of the people in the Electoral College. That is official and protected. So the court was really clear. Here's some unconstitutional actions that we are going to say are now insulated from any oversight. But they didn't turn it over and say, here's some actions that are definitely not protected, like calling up states and directing them to come up with, commit fraud. That's, there are people that have gone to prison in America for voting in the wrong precinct. A couple women in Texas, low-income women, English, I think, was not their first language. They had kids at home. They were imprisoned for mistakenly voting in the wrong precinct. Asking people to come up with fake slates of electors is fraud. That is interfering in an election. That is the fraud. That's the election fraud of 2020, right? Court was not willing to say, and actually said that may or may not be official. There's nothing in January 6th. The majority was willing to say, okay, we're going to put a red line around this, which leaves them this discretion, I think, in the next case. And this is definitely cynical thinking, or maybe this is not an optimist standing here, to say, okay, well, that president's actions, we're going to call that unofficial. So there still is, they've left themselves discretion to allow an indictment to go forward against a future president by not defining what is and is not official. They were really clear to say a lot of what happened on January 6th was official. They wouldn't say what was unofficial. So you could get a new scenario, because there aren't really any boundaries, where they don't like the president, and so they do allow the indictment to go forward. That's my answer to that. It's not that optimistic. Yes, ma'am.
I think that the Supreme Court has had to reverse itself in history, that they've gone back and gone with the opposite judgment that they would do. But I don't know how that happens. What is the mechanism to how can we rescue ourselves from this bad decision?
Well, there's been a constitutional amendment proposed in the House of Representatives that would really put the Constitution back where it was in May. It'd be fix it what they broke, and also ban self-pardons. The pardons are in there too.
That takes years.
Of course. I mean, the last one was in 1972, I think. I mean, there have been over 11,000 proposed amendments, but 27 have made it through. I think beyond that, I blame the Democrats, frankly, for not, in the House or the Senate Judiciary Committee, for not holding hearings on the conflicts of interest on the part of Samuel Alito and Clarence Thomas. Why we are not at least having hearings on C-SPAN. You have experts come and testify about ethics. Call Ginny Thomas to talk about who she called and why she called. I mean, that at least would put political heat, and the Senate, the Democrats have not done that, right? That's not on the Republicans. So I think public pressure, bringing some more of a drumbeat could create, maybe put some pressure on the justices. But to answer your question directly, there's a number of things Congress could do. Congress could amend the number of justices on the court. People derogatively call that court packing. I call it court unpacking because Mitch McConnell took Barack Obama's seat, and the Senate Majority Leader has no authority under the Constitution when it comes to appointing judges. So there is no such thing as a Senate Majority Leader in the Constitution. But Barack Obama didn't say anything. He didn't even make a speech, right? He didn't even complain. So there's pushback. So they could change it. The configuration of the Supreme Court has been anywhere from 5 to 11 justices. It's completely constitutional. You'd have to get over the filibuster to do it. Right, you need 10 votes from Republicans. They're not going to do that because this is a coup of all coups, what they've done with the Supreme Court. FDR, when his New Deal legislation was getting struck down by a conservative court, he had a very pliant Democratic majority in Congress, and he threatened to pack the court, and one of the justices finally caved and stopped using these old doctrines to strike down legislation. So we've seen that happen. They could also constrain the jurisdiction of the court. So what's the jurisdiction? It's the power of the court. There's two things the Supreme Court can do. There's something called original jurisdiction, which, believe it or not, you could initiate a lawsuit in the Supreme Court if you sue a state. It happens once or twice a year. And that would mean they would be hearing witnesses and taking all that stuff. Everything else is what's called appellate jurisdiction. And the Constitution specifically says the appellate jurisdiction is subject to exceptions or regulations that Congress can make. Congress could limit the kinds of cases that the Supreme Court gets. Congress could say, you know, for these kinds of constitutional issues, we're going to create a court that rotates judges from across the country, a panel of judges that are more representative of the country. You don't get those. You can have the statutory cases maybe, but with these heavy constitutional cases, no. All those judges have life tenure and salary protection. You're not changing the Constitution. The Constitution says nothing about, it just says a Supreme Court. It could just be Justice Roberts. And actually doesn't create any lower federal court judges. That was created by the First Judiciary Act. Congress creates all the lower federal courts. Tomorrow they could wipe all of it away and reconfigure the entire judiciary if they wanted. Perfectly constitutional. You would not need a constitutional amendment. So these are things Congress could do. There's been pressure on the Democrats to do something about the filibuster. Now, you may or may not know, part of the reason we have this Supreme Court is because under Mitch McConnell, the filibuster was killed for Supreme Court justices, right? So it used to be you needed a supermajority to get any justice, which means you have to get 10 people from the other side to like this person, which means it can't be a radical. The last 3 justices, Gorsuch, Barrett, and Kavanaugh, were post-filibuster, so there were bare majorities in the Senate. And because the red states tend to be less populated, Democrats are more in big cities. If you actually look at those 3 justices, a majority of Americans were represented by members of the Senate who did not vote for those justices. So they are actually a counter-democratic, counter-majoritarian body. The other thing I want to say, I mean, you know, the 1803 decision of Marbury versus Madison, okay, what did that hold? I mean, it's like a landmark case. It held that the Supreme Court gets to interpret the Constitution when it comes to the other branches. Guess what? That was a Supreme Court power grab, friends. That's not in the Constitution. It's not in the Constitution that the Supreme Court gets to do this stuff. They decided they get to do that stuff in Marbury versus Madison. For good reasons. Marshall was, you know, they were early and the states hated the national government and they had to establish some kind of authority. So there's reasons for it. But my point is, I think if the court continues on this path of becoming so hyper-political and ideological, and there could be a day we wake up and people are like, it's a joke court, I don't want to pay attention to it anymore. Donald Trump threatened to do that with a couple times, certainly when it came to the census. And the Supreme Court, Justice Roberts, Chief Justice Roberts, was the tie-breaking vote on whether, when it says, you know, people get counted under the census, it's only citizens. He wanted to narrow the census count. The Chief Justice sided with the more progressives at the time, and he threatened to just ignore the decision. So another concern I have is with this particular court, if Donald Trump's in office, you know, there might be, if they ever rule against him and he threatens to ignore them, they become obsolete. And they're pretty drunk on their power right now. So I think it creates an incentive for them to just do whatever he wants because then they stay relevant. Anyway, yes, sir.
I'm wondering, are there obvious historical trends and changes in trends in the use of the pardon? Like how many are granted, how many pardons are granted, what kind of people are pardoned, what kind of crimes are pardoned, you know, and does it change in what way across this?
Yeah, so I don't know the answer to the second part, what kind of people, what kind of crimes. There's so many pardons, and of course, the majority of them are at the state level, right? Because there are many more state crimes than there are federal crimes. And the other thing to keep in mind is the states, with I think the exception of 5 states, governors don't have unlimited power like the president. So this idea that the president has this unaccountable power is not borne out even in America, and it's certainly not borne out across the globe. A lot of countries, you need judicial review or legislative buy-in, or separate committees have to make the recommendation, or Justice Department guidelines. You have to wait 5 years to the end of your sentence in order to get a pardon. What I do know statistically, as I think I mentioned, is that the numbers of pardons have really dipped. There was a period, I think, in the mid-20th century where they were up a little bit, and they were certainly up you know, around when commutations started happening, shortening sentences. But in terms of the numbers, they've fluctuated from almost no pardons to a lot of pardons, and I don't have those statistics at the top of my head. But I think with the exception of so far Biden and Obama, every president since Reagan has, or I would say George H.W. Bush, have issued really controversial pardons. And that's become more of a problem. So George H.W. Bush, he pardoned Caspar Weinberger, Secretary of Defense, in connection with Iran-Contra, and shut that whole investigation down. And some people believe he was involved in his own wrongdoing. He was covering up for his own wrongdoing. I mentioned Bill Clinton pardoning Mark Rich. He said, I think, in the Washington Post or the New York Times, it was a mistake because it tarnished his reputation. But he also pardoned his brother-in-law. And then, of course, we saw the George W. Bush pardoning Scooter Libby. He actually commuted a sentence. That was one of Cheney's, his vice president's top people that was involved in outing a CIA agent, or who she was. And then, but, you know, the pardon palooza with Donald Trump, and I list some of them in my book, pretty reprehensible people, including his own father-in-law, Jared Kushner's father, who Chris Christie prosecuted, really egregious crimes. So I don't know. I haven't seen any place where that's been kind of like, there really are thousands and thousands of pardons. Yeah, it's a good question.
Just wondering about the types, too. I mean, you know, types of crimes that were pardoned in the 1800s.
Well, I mean, I think I don't,
It's a similar mix across types of.
I don't know the answer to that question, but my answer would probably be no, because I don't think there were the not kind of white collar crimes, right? I mean, the white collar people, I mean, Rudy Giuliani was peddling them for $2 million a pop, right? And there are people in Washington, the Harvard professor, what's his name? Anyway, what's it, Dershowitz also was taking money for pardons. So if, you know, George Bush, W. Bush, said when he left office, like he was sort of sickened by how there's this fever pitch of lobbying at the very last days. Donald Trump pardoned 60% of his pardons were at the end, right? So these are pardons that are bought and sold for favors, for money donations, for, you know, kickbacks, whatever. I don't know if it's kickback, but my point is that I think the white collar crimes are probably more late 20th century modern, because those laws just didn't exist at the time of the founding. But I don't know in terms of those trends. I don't know if that study's ever been done. It's a good question. Yeah. Yes, sir.
So one follow-up to the last thing you said on the previous question. As far as the Supreme Court being irrelevant if the president ignores them, that has happened in very important cases in the past, Trail of Tears most notably. I wonder how irrelevant the Supreme Court found itself when small to moderate genocide happened despite them saying no. And the second part is, you touched a little bit on the Supreme Court lying. Brett Kavanaugh lied during his confirmation about what roofing means, which seems like a good idea. Telling children what roofing is seems irresponsible. It's probably something. And then, but the Supreme Court has recently just admitted facts in its opinions that are demonstrably false. And it seems like at first it seemed like a horrible idea, and it still seems like a bad idea. It also seems like maybe they're signaling to people that you don't have to tell the truth to assert power. It's somewhat more scary than simply being mistaken. I wonder if you can speak to that.
Yeah, I mean, on the first point of the Trail of Tears, I mean, I think what I'm saying in terms of becoming irrelevant is irrelevant as to making decisions about a president's exercise of power, right? So that I think is the real problem. You empower the president, you then issue the ticket for speeding, and then the president says, I don't care. And that kind of gets to the question of both what the Supreme Court's doing in its opinions, what certain justices, when they were, you know, being nominated, said, you know, in this moment, there's no serious accountability for these justices. I mean, they, you know, I think it was Justice Jackson wrote a separate opinion in the immunity case. Her opinion, her concurring opinion, or dissenting opinion, was about not the power, not the aggrandizement of the power of the president, but the power grab by the Supreme Court. And, you know, I think that is the more dangerous one. It's not just, you know, someone mentioned, well, the court reverses itself. And I think Justice Kavanaugh said that around Roe versus Wade. But Dobbs was the first case in the history of the Supreme Court where the court reversed itself to take a right away from people. You know, that's different from Brown versus Board of Education overruling Plessy versus Ferguson, which was, you know, entrenching or making constitutional separate but equal, which, by the way, I think the court is going back there. If you carefully read the Harvard affirmative action case, by declaring the Constitution colorblind, I think they're setting it up to strike down civil rights laws, anything that makes a distinction on the basis of race. And there's a lot of what's happening are these sleights of hands that are below. This is why I've written these books, to try to get people to be encouraged to have a basic level of working knowledge on how it functions. Because, you know, I do this with my students. What does it mean? What does discrimination mean? What is remediation for discrimination? And we put it all on the board. Like, what does discrimination mean? Okay, it's making a distinction, but it's making a distinction for a reason. How do you determine that? It's actually a state of mind. It's a belief system. You can't actually prove that. It's very difficult to prove that. You don't have the smoking gun of that, right? And then it's like, well, how do you remedy that? well, it's not really bare equality. You've got to do something to make up for the fact that populations of people are starting the race miles before everybody else. So there is a remediation piece to it, and there's also a history to it. The 14th Amendment came after the Civil War. It was not meant to be colorblind. It was specifically meant to remediate and to bring a population of people that had been enslaved and disenfranchised, or not even, for the first time into it. So it had a whole remediation principle. And now all of a sudden, the majority in the affirmative action case declares the Constitution colorblind, picking up rhetoric from Justice Harlan's dissent in Plessy, which is not what he meant. So that means no distinctions on the basis of race. That we have to, because that's just being racist, and that's what the 4th and 20th Amendment doesn't want. So I agree with you. I don't know about, in the top of my mind, if there's affirmative lives and opinions, but I can go on and on. But what I want to say about that is I've been teaching for a while. I've been teaching law students now for 17 years. It is very difficult now to reconcile and to square some of these circles. I don't know how to teach this in a way, and there's a big New York Times op-ed signed by a lot of very, fancy constitutional law professors in the country saying the same thing. There's not an intellectually honest through line, right? So you're going to say, oh, history and tradition for abortion, send it back to the states. But the history and tradition, they took us back to 13th century England when they were, burning women at the stake. That's before there was even a constitution. So what is the history? And then you take Bruin, guns, 100 years old is not old enough. And even though, states can regulate people's uteruses and whether they become government-sponsored breeders or mandated breeders, that's a federal, we ought to leave that to the voters. But when it comes to keeping people safe on the streets, we're not going to trust the voters to enact concealed carry weapons 100 years ago. So my point, so now what do? I just started teaching a course on the Supreme Court. I had the big whiteboard, and we write on the board all the ways that you can resolve ambiguity in language. Poems are ambiguous. The Constitution's ambiguous. The Bible's ambiguous. I mean, this stuff is all ambiguous. So what do? You look at the plain language. You look at dictionary definitions. You look at the purposes behind it. Eventually we get to morality, and I play a very disturbing speech by Justice Alito, where he talks about the morality of Christianity and how atheism or agnosticism is amoral and is a problem and a scourge in American society, right? We could talk about international law. You can talk about philosophy, right? But the point is, you're using tools to resolve ambiguity. And my argument is, if you're going to use history and tradition and textualism and originalism, you better be consistent about it. Which I would say Justice Scalia for the most part was, except for Bush versus Gore. That's another story. That's where he lost my respect. Yeah, he was in Heller. He wrote the majority in Heller, which is a case that basically converted a militia reading of the Second Amendment into an individual arms reading. But the reason he wasn't totally inconsistent there was his rationale in Heller was around protection of your home. So all he said in Heller was, and he was actually a very pro-criminal defendant around the Fourth Amendment stuff, and what he said in Heller was, you have a right in your home to have a handgun for self-protection. And he was very clear, this doesn't mean other weapons. And then that just went, crazy with this current court. But they had to pull it back in Rahimi this term, which was about, whether domestic violence abusers could have guns. There was a law banning that. And Justice Thomas wrote a scathing dissent. He was so angry because they abandoned this history and tradition test. It's like, we'll pick it up when we like it, when we don't like. That's the exercise of discretion, of subjectivity, which they're not elected. They're not supposed to be doing that. So that's a long answer to your question. I don't disagree with you, and it's harder and harder to teach constitutional law, but that's what I've been doing, is just, if the goal for my students is for them to leave and understand these are hard questions, and there aren't good judges and bad judges, there aren't right answers and wrong answers, it's not black and it's white or whatever, red and blue, like there's this bifurcated, polarized thinking that, and I know we have some youth in the audience, I see increasingly coming into the law school classroom, and that is really disturbing. So I spend more time than I ever have just trying to disabuse young people of the idea that hard questions have easy answers, and the way you answer it is you pick your team. Yeah. I think we have a few more minutes. Yes, sir.
So I'm interested in the unwritten custom and culture around using pardons. So you were talking about how, now it seems like it's a formally administrative process, right? There's an office, there's principles, metrics of certain sort, right? And then
Well, there's guidelines. There's guidelines that the Office of Pardon Attorney uses.
So, but what about going back in history? I'm thinking about the 18th, 19th century. How did pardons or requests for pardons show up in front of presidents? And was there lobbying then too? Or was it just good old boy networks? Or what, do we have any?
I don't know. All I know is that there were fewer, and so the president read them. And at one point, this, it was within the Secretary of State's office, so it's moved around a bit. And I can't remember off the top of my head when the official Office of the Pardon Attorney happened. But also, Donald Trump has been bypassing that like other presidents haven't done. There are some people that argue that the Justice Department shouldn't be the ones making the recommendations because they're the prosecutors, or at least their colleagues, put these people in jail. So there's an argument to be made that, well, you could have an independent commission, and that happens in other places. And on the independent commission, you have psychologists, you have, prison justice experts, you have, former inmates, maybe, you have members of the community, you have a cross-section. I think if you made that mandatory, or at least the president would have to be bound by that, that would be unconstitutional. But I argue you could at least, Congress could create that commission, have all the applications go through there, and then have a public record of which the president rejects and which they accept and why. But there really are a lot of them. There's 11,000, I think, just for Donald Trump. But to answer your historical question, yeah, that's a great question. I didn't do the deep historical dive. Yeah, but it's a great one. I'll put in the back of my head. I don't know. Yeah. Yes, Aaron.
I'm curious if the pardon has any power to also protect the president against actions that are unconstitutional as opposed to actions that are simply illegal. Is there something that the president could also do with the power of the pardon to simply tell the Supreme Court, I'm not going to listen to your ruling on X, Y, Z?
Well, a pardon arises when there's a crime that is triggered, right? So, the president, well, there's a couple things. So any illegal actions that could give rise to a criminal charge, and in certain circumstances, constitutional violations can definitely lead to criminal charges. The other big problem with this decision is the court went out of its way to also say that any evidence of the official act cannot be used in a trial, okay? So I was overheard in the green room at CNN, some former members of Donald Trump chatting, his lawyers. They represented, these people I think were involved in the congressional investigations, who said, oh, now with this, we just would say no to subpoenas, right? Because if you can't use it at a trial, why should you get it? Now, I think what the court really did was really overrule Nixon versus US, where the court 9-0 forced Nixon to turn over the Watergate tapes to in the context of a criminal investigation. But now they also said that that information cannot see the light of day. So to answer your question, one of my concerns around your question is we wouldn't even know. Like if we would, there's a lot of stuff we don't know that's national security, top secret, unless it made its way to Mar-a-Lago, and then we don't even know where it is right now. Which we don't. They're 40-something red wells. We still don't know where they are, friends. We don't know where the empty contents made its way. But I think this is just going to increase the shroud of secrecy around presidential actions. So if some of that channeling was happening, we might not know. Now, like former Attorney General Bill Barr came out and said, okay, but a bribe, a pardon, a purchased pardon, would still be, you could still prosecute that. But the problem with that is a bribe's a quid pro quo. You give me money, I'll give you a pardon. If the part of the giving of the pardon is now out of the case, all you have is giving money, and that's not illegal. It's not illegal to give or take money, millions of dollars, right? I mean, you could maybe, you could violate tax laws or other things, but the point is the exchange, the actual giving of money itself is not a crime in the context of a bribe. It's the giving of money in exchange for an official act. It's purchasing an official act. If that official act is now out of the picture for purposes of a prosecution, there's no way you could prosecute a sold pardon. The other thing the Supreme Court did is say motive is never, you cannot look into a president's motive. That also kills any prosecution, potentially, if it's an official act. So, for example, if you order your SEAL Team 6 to assassinate a political rival, like the leading presidential candidate who's running against you in the next election, right? Or for it, the person who's sleeping with your spouse, I don't know. If you have some nefarious intent, or you order someone assassinated, like Osama bin Laden, to protect the public, those are two different things probably for a voter, right? Everybody rejoiced, a lot of people anyway, when the Obama administration. So the motive matters. And actually that's the line between criminal and civil liability, is what we call mens rea. The court said that's out of the picture too. So by taking out of any criminal prosecution both the act that's official and the reason behind the act, that is now insulating all kinds of nefarious and criminal conduct. So at the end of the day, and then, I think we can wrap up soon, but at the end of the day, we're kind of left, to answer your question, we're left with, we better really elect people with integrity, which wasn't good enough for the framers. I mean, they wanted elections, but they also, George Washington turned down a monarchy, right? Benjamin Franklin said it's a republic if you can keep it. I mean, I don't think they expected it to actually function, but they wanted to create this idea, all men are created equal. What a concept. Thousands of years of hierarchies, and it's the inverted triangle. I'll also say, I think we have to elect people with integrity, and in this election, it has to be with massive margins. Because I think the way possibly this is going to go awry, and I know we're getting off the pardon, but is not so much about the popular vote or even the Electoral College. It's about states refusing to certify an election. And then under the 12th Amendment, it could go to another January 6th where the House of Representatives would choose the president. Right now it's controlled by the Republican Party. So I think the way around that is you can't dibble or dabble around fake ballots, because there'll just be so many that the allegations of fraud will just on their face be silly. But if it's, 2000 was resolved by 357 votes or something, under 500 votes in the state of Florida. And that gave us the Iraq War. Al Gore was would have been the climate president, imagine. He was talking about climate before anybody. I remember I played his video to one of my first law school classes in Oklahoma a long time ago. So anyway, elections do matter, but I think we need huge margins. And I don't know that people really understand the stakes, so anyway. That's.
The other video with Al Gore and climate, I think about 1982, Carl Sagan was explaining to Al Gore and about 3 other senators the impending danger of the climate problem.
I love Carl Sagan. He was at Cornell when I was there. Oh, that's good. I'll look it up. Yeah, thank you. Anyway, everybody, enjoy the football, enjoy everything. Thank you for the great questions. Appreciate your coming. And buy the book.